Hello, everyone. Welcome to our monthly presentation. I'm Erin Hamrick, the marketing manager at 5 Star Chemicals. We're really excited about this month's presentation. And so just a couple of housekeeping things. Feel free to say hi in the chat over to the right, say where you're listening in from, say hello to your fellow brewers. And if you do have a question during the presentation, please use the bottom Ask a Question prompt. That way others can vote if they'd like to hear the answer to that. We can be sure that we get through all of the questions. We will be having a question and answer session after the presentation. Another reminder is that this is recorded. So this will be recorded. I will send it out to everyone who has signed up for the presentation, and we will have it on our YouTube channel as well. The next presentation for next month will be August 25th, and that is Don't Grow Yourself Broke, another financing presentation. And without further ado, I'd like to introduce Aaron Weiss. He is a partner at the law firm of Zimmer Coons, which is headquartered in Pittsburgh. In addition to being an attorney, Aaron is an avid home brewer and has been brewing beer since his first year of law school. So I'm sure he can tell us how that helped him get through law school, as we all know how that helps us get through sometimes. He is the head of his firm's brewery and liquor law practice, which represents a number of breweries throughout Pennsylvania. Aaron was born and raised in Pittsburgh and now has a family of his own, including a 20-month-old who loves helping brew beer on the weekends. So thank you, Aaron, for joining us, and I will hand it over to him.
Thank you very much, Erin. So thanks everyone for being here today and showing up from all around the country, it looks like, to listen to the presentation. And thank you to 5-Star. I actually met Erin when I gave a similar presentation at the National Homebrew Con that took place here in Pittsburgh just last month. So I'm glad to get it to a larger and more nationwide audience here as well. A little bit about me to get started. I am an attorney here in Pittsburgh, Pennsylvania. Our firm is about 30 attorneys and handles a wide array of different issues, start to finish, helping new companies get started, contracts, licensing, things like that, and also all the way through the end process for existing businesses. If there's litigation or issues that arise, we deal with that as well. So we have a good breadth of knowledge from all across the realm of anything that a business could need. I started homebrewing during law school, which is really what gave me this particular area of interest. And also the laws here in Pennsylvania, like many other states, have really changed and helped over the last 5 to 7 years to allow what has been this mass expansion of breweries. So we went from maybe having a handful back in the year 2010 that now we're up to, I think the most recent count was 47 or 48 just here within the city of Pittsburgh proper alone. So it's been great to see. There are a lot of really fun people and a lot of really fun clients that I enjoy working with. And I'm happy to share some of the knowledge and the experience that I've had over the process. So with that, let's get started. So here's just a couple pictures to prove my non-legal resume that I truly do brew beer. The first one is Wiggle Whiskey, which is a local distillery here. That is my wife and I and my parents in the background. We entered the homebrew competition in 2014. That is my now 20-month-old Carson, who was helping me with the National Homebrew competition in 2021. And then we also collaborated with a business out of Ohio, Crafted Culture, from Columbus, who we give out beer at the Barrel and Flow Festival, which if any of you are near the Midwest part of the country, I would highly recommend coming to that. It's taking place August 12th and 13th and is a great festival. It was rated very highly by USA Today and brings a lot of diversity to beer and has a lot of limited collaboration. So it's a lot of fun. So the goal of this presentation, many of you may and hopefully will eventually, as you continue to homebrew or get more towards that level of creating a business, want to take the next steps to open a professional brewery. So the goal of this presentation is to explain to you the what, the why, and the how as far as opening a brewery from the legal perspective. Really, when you make this decision, it should be an exciting and a stress-free process, and something that can be made a lot easier and make you more comfortable with the assistance of knowledgeable and experienced legal counsel. I always say you can do a lot of things yourself, like I could figure out my own finances or do different things like that. But at the same time, I hire someone who knows what they're doing for that, because it gives me more peace of mind at night that I don't have to wonder if the research I did on Google is right or if I found the right answer, and someone who really has that specialty knowledge. So, talking about the what, all aspects of alcohol are regulated by the government. That includes both the state and the federal government. So, for example, if some of you didn't know, it was not always legal to homebrew beer. That wasn't until 1978 that federally at that level they permitted it, but then it also was required to be approved by each of the states individually. So some of you might be surprised to know that it wasn't even 10 years ago that homebrewing was still illegal in at least 2 of the states in the United States, Mississippi and Alabama. When you are home brewing, of course, you can do a maximum of 100 gallons per year per adult who's 21 plus. If you live with another adult or multiple, that doubles and you can do 200 gallons. So that's a lot. And I imagine most people won't hit that amount. But it's good to know that there is technically rules and requirements as far as that goes. Once you make the step from home brewing to commercial, there's a lot of legal red tape that you have to cross. So there's different licenses for the different types of alcohols and businesses. You have manufacturing versus distribution. You also, if you are manufacturing, which is of course what a brewery is, not all manufacturers have the same type of license. If you brew beer, that's different than if you have wine, or different than if you make hard alcohol like a distillery. So again, each one has their own level of rules, requirements, and benefits as well, as far as what the license permits you and restricts you from doing. So what is beer? A brewery is a business that produces malt beverages and operates a brew pub or microbrewery. Beer is anything that is at least 0.5% of alcohol by volume, and it includes this various list of ale, porter, stout, other similarly fermented beverages. That's 27 CFR is the Code of Federal Register. That's the section of the federal law that gives you this definition. But essentially, there are now a lot of businesses who are interested in non-alcoholic beer. As long as you keep it below 0.5% of ABV, as far as the government is concerned, it is not alcohol and is not regulated the same. However, most people that brew beer, of course, you are going to fall under this category of alcoholic beer, and then you're required to go through the process of having a formal brewery license. So we talked about the what very briefly. Let's talk about the why. Why is there all this crazy regulation when it comes to alcohol and beer? Whereas if you wanted to, go open a coffee shop tomorrow, none of this would be a requirement for you, and it would be, frankly, a lot easier. So originally, the United States had what I'm sure most of you have heard of, the 3-tier system. Tier 1 was your producers of alcohol. That would be a manufacturer, such as a brewery, a winery, things like that. Tier 2 would be your distributors, the middleman who takes the beer from the manufacturer and then delivers it to ultimately the location where it's going to be sold to the consumer. Both tiers 1 and 2 are today regulated by the federal government. Tier 3 is your retailer, so a bar, a restaurant, whatever it is who actually sells to the end consumer. If you are a tier 3 retailer, such as a bar or a restaurant, you actually are not regulated by the federal government, but you still have to comply with whatever the state rules are for your state. So that was the old system. That was pre-prohibition, when alcohol was originally permitted in the United States. Then we're all familiar with the prohibition period, where alcohol was completely illegal at the federal level. We'll skip past that because it's a boring time in our history. It was repealed by the 21st Amendment in 1933. And then that permitted alcohol to be allowed again. And it created a new atmosphere as to what are the rules and regulations going to be in this new era of alcohol. So the Supreme Court of the United States, in this decision, Indianapolis Brewing Company versus Liquor Control from the year 1939, basically considered the issue and held that states have the authority to regulate their own alcohol industries as they see fit. So really, that's why you see such a diversity among the states, and why it's so different depending on where you live, what the rules and requirements are. Just to give you an example, here in Pennsylvania, I cannot go buy hard alcohol from a local gas station. I know a lot of states do let you do that. But here in Pennsylvania, it's only by the state's wine and spirit store. There is one really interesting exception, and someone who's kind of created a gray area loophole for that here. But vastly speaking, that is the rule. Similarly, many of you may live in a state where you as a brewery are required to use a middleman to distribute your beer before you can actually give it to anyone to consume. I think Florida, I was speaking with someone at the National Homebrew Convention who said that's the case for them. Whereas, and we'll discuss a little bit here in Pennsylvania, post 2015, the laws have changed and permitted a brewery to not only sell direct to consumer, but also to self-distribute, which has been a huge benefit to a lot of breweries here in our area. So many states have had a recent boom in microbreweries, and that's based on the changing legislation and the benefits that those legislative changes permit. It's a good thing as far as most governments are concerned to have a brewery in the area. They employ people, they pay taxes. It's a good gathering place for the community. Most breweries are very welcoming and accepting area to all sorts of different backgrounds. And it's maybe a little bit of a better, in my personal opinion, clientele than, just a local bar who, people may be going there more for the purpose of drinking heavily than trying out really interesting, unique beers. So that's just my own personal opinion as to maybe why some of the changes have happened. But regardless, in whatever state you live in, it's likely that those state legislatures have made certain changes over the last few years to help breweries along their path. So just to give you the examples and a quick rundown here in Pennsylvania, and in general, I am going to focus nationwide because I know that impacts everyone here, whereas PA is a little bit more specific, but it gives you a good example of how a state works because, of course, wherever you are, that is a requirement. So some of the biggest benefits to a brewery post 2015 here in Pennsylvania, first of all, there's no finite number of licenses available. So here, in order to have a restaurant license, we actually have a set number. I believe way back in the day, they took a census and said, okay, we're going to have one restaurant license for every 3,000 residents. And that is like the maximum amount that we'll ever have. And it's a finite number. So in order to have a bar license, you would have to buy one off of someone else. So they become very expensive. Honestly, and most times it'll be six figures. And you have to go through the process of transferring that license, ownership, location, if there's an issue. Versus if you're a brewery, you can actually invent a new alcohol license from scratch. So there's no finite number, and it's your license that's your own, the way you made it, how you want it to be. So that's a big benefit. In addition, a brewery itself has both the manufacturing location, the general license, and it has two storage facilities. So you'll see, if you ever see a brewery that has multiple locations, it's likely because the local state has a similar rule where they give storage facilities. Here in PA, you can only physically brew out of one location, but then you can ship your beer to the other two locations and still serve it as if it was a tap room. There's actually pending legislation right now to even increase that number to up to 5 storage facilities. We'll see how that goes, but for right now, it still sits at 2. Another big benefit is self-distribution and the ability to ship direct to a consumer. I'm sure a lot of you have heard about distributors and that can be a very complicated process. And in the law in general, courts hate contracts in perpetuity, and there has to be a way to get out of them if something happens. Far and apart from anything else, like one of the only exceptions to that is alcohol distributors. And so if you get locked in with a distributor, it can be in perpetuity. And a lot of breweries now are choosing not to do so because, at least here in Pennsylvania, they have the ability to self-distribute and ship direct to the consumer. Additionally, Here in Pennsylvania, if you are a brewery, you can also sell other types of beer and spirits, whether it be, another brewery, cider, wine, or hard alcohol. The only rule is it has to also be manufactured in the state of Pennsylvania, and also your own sales have to make up 50% of it. So you can't create a new brewery license tomorrow, home brew your own 5-gallon batches at a time, sell everyone else's beer, and call yourself a brewery. That's not going to fly. In my personal opinion as well, I think this rule could be challenged in the fact that they're not letting anyone from another state be sold at a brewery. It, in my opinion, would violate what's called the Dormant Commerce Clause of the Constitution, which violates interstate travel. But that's something that if a brewery wanted to challenge, I would certainly be willing to discuss with them, and you'd have to fight that battle against the government. But that would be something that could be worthwhile if you can then sell other, beer, wine, spirit from another state. So speaking of shipping, as I'm sure many of you know from being homebrewers, it is illegal to ship alcohol via the United States Postal Service here in the year 2022. Each state also has the ability to regulate within itself whether or not you can ship beer at all. The good news is you as a brewery, a licensed brewer, you can use UPS, FedEx, or some other private entity. They do not have the same restriction as USPS. So a lot of breweries who do sell direct to consumer via the mail, you can use them, UPS, FedEx, DHS, whatever the other ones are, DHS, DHL, I forget the company that's yellow. So those are options for you. There is also pending legislation that the Brewers Association has been working on heavily. That's the United States Postal Service Shipping Equity Act of 2021. House resolution is 3287. Essentially, they're trying to change that rule so that you could ship via USPS. That would obviously open up. They might be cheaper in the end and permit, a broader range of people to be reached, because obviously the federal USPS reaches everyone for mail. If you are interested, I have a QR code on the screen. You're welcome to take a picture of it, and that will actually take you to a link that basically will then send something to your local legislators that will say you're supportive of this legislation and would like it to be passed. So if you're interested, feel free to take a snapshot of that. And while anyone is doing that, I'll just mention that in making this slide, for anyone who's a South Park fan, it made me think of the episode where they burned down the Federal Express only to find out that it is not affiliated with the government, which is exactly why FedEx lets you ship beer if you're a brewery. Okay, so we spent a little bit of time talking about the what and the why. The majority of my presentation, because I think it's what most of you will be interested in, is the how. So you've thought about it, you like beer, you want to make a business in a brewery. So what is the actual process from having that concept and actually taking it to fruition to where you can then be a licensed brewery selling beer to the public? So the first step is forming a business. Anytime that you're doing a business venture or selling things as to a consumer, you want to have a formal business as opposed to doing it in your own name. Why? Number one, it's going to be required for your alcohol license a lot of the time. But more importantly than that, it actually provides you with legal protection. If you create whatever it may be, an LLC, a partnership, a corporation, it insulates you, the individual, from liability. Again, like any law, there's exceptions and rules that can be, raised to challenge that. But for the most part, if you have a business and you complete corporate formality and maintain it, for example, different business accounts, you're not commingling funds between yourself and the business, you're not taking out from the business account a loan to pay your house, things like that. It protects you individually from a lot of litigation. And it also then means that if ultimately the business goes under or closes, no one can come after your house and your personal assets. So it's something that is generally simple to do and really protects you a lot in the long run. Again, this varies by state, but for the most part, it just requires a formal filing with the state and then an operating agreement, something that spells out the terms of how that business is going to run. That's something that, again, we handle routinely and have helped a number of businesses, including breweries, for, and are happy to do so if anyone has questions. Let me back up as well and mention, because I know we do have a nationwide audience, and I mentioned that we're from Pittsburgh. So our firm is, generally speaking, a regional firm. We handle business in Pennsylvania, Ohio, and West Virginia for the most part. We do have a couple of other attorneys barred in different states. New York, we might have a one or two in Maryland, things like that. But no matter where you are in the country, if you have listened to this presentation and you are interested in learning more or hearing about this, feel free. My contact information is going to be at the end. Shoot me an email. And if you're in a jurisdiction that I can't personally help you with, or a state that we don't do, I'll find you the right person that can do it, no matter what the issue is, whether it's a brewery or something other legally related. We have contacts and people that we work with in every state and refer business to one another. And it usually is a lot more reassuring to someone to have us find the right person for you than just start with a Google search of who are the attorneys in your area, and you don't know who's paid for an ad, who's a good attorney versus not as good of an attorney, things like that. So I invite you, no matter where you are in the country, if you're ever considering doing this kind of business or another business, always feel free to shoot me an email. If I can help you with it, I will. And if I cannot, I'll definitely find you the right person to do it. So moving on, let's talk about choosing a location. So once you have your business formed, the next step is finding a location. You can do different things. You don't need a brick and mortar space for a brewery. You can do an alternating proprietorship. You can contract brew with an existing brewery and then just distribute. But there are some benefits to the brick and mortar. You don't need to own the building. You can rent it. That's perfectly fine. And you can be in a part of town that rent might not cost that much. The big benefits to having your own space is it comes with freedom, the creative freedom to set up the brewery the way you want, the equipment. You can buy the size that you want, the type of equipment that you want, everything to what you want to brew on. You also control the hours that it's open, and you control the way you design the space. There's a lot of benefits to all of those things. So I would encourage those of you who are thinking about it and on the fence, it may be worth it to do the brick and mortar. Another big thing is customer loyalty. To a lot of these breweries, when you go to the local distributor, there's a million beers to choose from. And a lot of times the reason someone will pick the beer they do is a brand recognition or a loyalty to it. So if they've been to your brewery, they've talked to you as the person behind the bar or the owner, they've toured the facility, it might encourage them to pick your beer over another one. So it can actually increase your sales, if you have that customer base and loyalty. So if you're going to go with a brick and mortar, some things to consider. Number one, don't put it in a dry area where you're not allowed to serve alcohol. A good example of that, I think Jack Daniel's is in a dry part of Kentucky, and that creates all sorts of interesting legal issues. It's a lot easier to just put it somewhere where people can freely drink while they're at your location. So don't go somewhere dry. Also, residential versus commercial. Are you going to be in a house, more or less, where you have like 80-year-old neighbors around you who are going to be upset if you're making noise at 8 p.m. That's an issue for you. If you're going to have music or things like that. Not saying that that's against, your ability under your license, but it's a lot easier if you have cooperative and friendly neighbors, other businesses or things like that, who aren't going to create an issue, call the police, call the liquor control on you, things like that. If you are in an area that's residential, it's totally fine, and a lot of breweries do it. I would highly encourage you, go knock on every neighbor's door. Give them your cell phone number. Say, hey, I'm opening a brewery. I'd love to come give you a tour. We want to be good for the community. We're trying to bring people in. If you ever have an issue, here's my cell. Because then maybe they'll call you instead of calling the police or the liquor control, and it really saves you a lot of time. We have really good relationships with our neighbors, and it makes our lives a lot easier when you're not fighting with neighbors who can really make your life a lot more difficult. Also think about permitting and zoning issues. There's a lot of rules and regulations that go into building a brewery, the plumbing, the electric, fireproofing things. So you're going to need to know who the local government is, who's the board that's ultimately going to approve these plans. If there's a brewery already in your area, ask them what the process was like. Was the local government happy, cooperative, wanted you to be there, or were they really difficult to deal with and made it, you jump through a bunch of red tape? Those are things that you want to think about, because it can really make or break not only, the time that it takes to open up the brewery, but once you're there, the relationship that you have with the community. So think about all those things while you're picking a location. If you need help finding a location, again, here in Pennsylvania, our team works with a commercial realtor and a team of architects that are familiar with breweries and have done a number of them with us as well. It's good to have that team because we all know what the other one's doing and can work hand in hand to make sure that everything is up to par. So, if the architect sends me drawings that I know won't be approved, I'll just email her back and say, hey, can you make this quick change? Because it'll save us 5 steps further down the road when the PLCB is going to reject this for X reason or something like that. So if you're using us, if you're using a different firm, it's always good to see who their team is and how they can assist and get you to the right people. In addition to having that base, we also draft, review, and negotiate leases. Leases are always something that you're going to want to look at and consider, not just sign the first thing that comes your way. Easy examples. You don't want to sign something that says, I'm going to move in on September 1st, 2022, and start paying rent, because your license may not be up and running at that time. And then you're stuck paying the rent while your license is pending. So what we do is we put in a licensing contingency in a lot of the leases that says the lease will start on X day pending federal and state approval. And then if your approval hasn't come in yet, you and the landlord both know that you're not paying rent until that time. That's a big benefit. Also, make sure you're only signing the lease in the business's name and not your name individually. We talked about with business formation that you want to insulate yourself from liability. If your name is on that lease, then someone who's suing is going to go after you personally. So you want to keep your business name only on that document. Now, you can sign it in your name on behalf of the business, but you don't want to enter it John Doe as the tenant, because that's going to create issues. I have one of those ongoing right now where, they joined on with me later on than when they did their lease, and we're currently fighting that in court over whether or not they're going to be voluntarily dropped from a case individually because the name on the lease was an individual. So that's just 2 easy examples of where, it's worth your while to have a lawyer review the contract up front, because spending a little bit of time up front can save you tons of hours of fighting about something on the back end. Next is insurance. There's a lot of types of insurance that apply in opening up a brewery and different kinds to consider. It's up to you which ones you want to get. Depending on the state, you may not even need to have any of them, but it's always a good business idea to have insurance and have a team that if something goes wrong, you're protected and insulated again, so that it's them helping you out, the insurance company, as opposed to you dealing with it yourself, where one lawsuit, quite frankly, depending on your size and how new you are, could run you out of business. So there's different types of insurance to consider. Commercial general liability, that covers your business as a whole. Slip and falls, if there's an issue, with like an employee or things like that. If there's a hurricane comes and hits the business, that all generally falls under commercial general. Separate from that is liquor liability. That's where you have, someone who is overserved allegedly at your location, or if you brew a bad batch of beer, or if the beer gets skunked. It's a separate kind of insurance. So, you might want to talk to your lawyer about, depending on what you want coverage for, which kinds of things do you need? Because if you only get commercial general liability and then someone sues you for overserving them, your liquor liability, unless you have that, the commercial will not apply. Also, you have automobile insurance. Of course, if you're going to self-distribute and drive, you need that auto insurance. Advertising insurance will cover in certain circumstances, if you're making representations or advertisements and then you get sued for things like defamation or things like that, it can apply. Umbrella is an overarching term for if you want extra insurance coverage beyond the amount that you have. So your insurance will pay up to X dollars. A common amount for commercial businesses is $1 million. If you want to up it to like 5 million, then you can get umbrella coverage. And the benefit is that if they go over that $1 million, you're not paying for it out of pocket. So that's a lot of stuff to consider. Again, you can work with a broker and they can help you, but also have your lawyer look at it. And with the idea of what legal issues could arise, do you have the right insurance in place? Another really important thing about insurance, and the really good news, is that your insurance may cover both the cost of defense and any ultimate award if you do get sued. Again, it depends on your contract, your insurance policy, what the underlying issue is. But the main 2 things to be aware of are there's really 2 buckets of insurance. There's the duty to defend and there's the duty to indemnify. So let's use an easy example. If it's alleged that your brewery overserves someone and then they get injured and they sue you, the duty to defend is where the insurance company will pay for me as your lawyer to represent you. And my hourly rate, legal fees, all of that is covered by them. Then the duty to indemnify is whatever amount of settlement is ultimately reached or verdict is ultimately reached. That's the amount that they would cover. Without those two things, the duties in place, you would have to pay those as your own, business out of pocket if you don't have insurance. So it's all based on the language of your contract. But again, give it to your lawyer. We'll review it. We'll interpret it. We'll determine if someone is denied coverage or if there's an issue, if you should be getting coverage, if there was a claim and something went wrong. Also, it's a really good idea. As soon as you get that insurance in place, go ahead and email your insurance carrier and say, hey, I already have a lawyer. They do this kind of work, insurance defense litigation, and we'd love to add them to our approved list of counsel. Then I reach out to the company and I say, hey, what do you need on our end? We do this routinely. We cover litigation. We'll give you our rates. We'll give you our, legal resume and see if we can get approved. It's better to do that in advance because then as soon as you have an issue, it comes right to us. As opposed to if you've already been sued, we're kind of scrambling to get in, hopefully before they assign a different attorney who you're not familiar with. So let's talk about licensing. This is probably the biggest part for someone who's opening a brewery. How are you going to get your license? You need 2 licenses to be a brewery. Like I said, you need the federal and you need the state. So for federal, which I'll focus most of my time on, it can generally, it'll take usually about 30 to 40 days once you submit the application, but it can take longer, 75 plus. Honestly, it depends on things like, is the government in a shutdown? Things like that can slow it down. My statement up at the top, it can take up to 6 months, usually includes the amount of time for your time to gather all the necessary documents and things like that. So when you're starting this process to when you're gathering everything and submitting it to the federal government, all of that can take up to 6 months. So when you're doing your license, it's governed by the TTB, which the A for alcohol in TTB, I guess, is silent. It's the Alcohol and Tobacco Tax and Trade Bureau. A lot of people think breweries are governed by the ATF because they've heard alcohol, tobacco, and firearms. That's not the case. So it's the TTB. There is no fee. It costs nothing to submit a brewery license with the federal government. You're going to pay your lawyer, the fee to submit it, but there's no actual filing fee. The general areas of inquiry that the federal government is concerned with are they want your business documents. Again, what is your business formation, the articles and the operating agreement. They're going to want proof of the ability that you have to be in that space, whether it be a lease or the deed. You're also going to need the deed either way because part of your federal license is going to ask for the property description. And by that, I mean like that old school 1800s, turn left at this tree, take 30 paces and move it over here. And then that's our boundary line of our property. I have no godly idea why the TTB wants that information, but it's necessary. If you don't have the deed, don't worry about it. They're usually available publicly. We can find them pretty quickly and get it for you. The cost is like $1 or something a page, so it doesn't take too much. You'll need the signing authority form 5100.1. That gives you as the individual the signing authority on behalf of your business. You'll also need the power of attorney form. That lets me log in to my account on the TTB and submit all this on your behalf and say that I represent you. That's another form that we can send that you just sign. They'll need the brewery diagram, the dimensions, where are the entrances, what's the size of the equipment, how are you going to secure the facility, meaning like are there locks on the doors, are you going to have cameras, how are you going to keep people out of the physical brewery while they're just in your tap room space, things like that. They want all that. The federal government doesn't care so much, but states really want to know the measurements to a T of like how big is each space. They also want to know your funds. Who gave you gifts for this? Did you take out a loan? Did you use your personal bank accounts? Things like that. You're going to have to give them all that information. They want to make sure that the money is legitimate and you haven't done something illegal to get the funds to open up the brewery. You're also going to have to do a personnel questionnaire for any of yourself as the owners, the officers, the managers, to make sure that all your background information so they can run a public record check on you. Make sure that you're okay to open up a brewery. And by that, I don't mean like, oh, I had a traffic ticket. That's fine. I had a DUI a couple years ago that, we got accelerated rehabilitative disposition. That's fine. They're looking more for like something that's really going to preclude you from being a lawful business owner, things like fraud or issues like that. That's the document gathering that the federal government wants. It's completed entirely by submitting it online. You don't have to meet with anyone. No one comes out to visit you. It's generally a very hands-off process. In addition, there's some things you have to consider in making your application. Are you going to be a brewery or a brew pub? The main difference there is, are you acting as a restaurant as well, where people are coming to eat, sit down, get a full meal, where you happen to also serve beer? That's a brew pub. Or are you a brewery where, you're mainly serving people beer? You're going to have food on site, but it's not like the main point or the focal point, and they're not sitting down for a full meal. Either one's fine. It's really just up to you what you're doing. The other thing that can make you a brew pub is if you're going lines from the fermenters direct into the tap, as opposed to kegging and then bottling from there. So that might also make you a brew pub. Also, depending on that, again, you're going to have to tell the government how you want to measure your beer. If you're going direct through a line, what sort of meters are you going to be using to measure the amount? Because they really care about their taxes and how much beer you're making to tax you on. So that's really important to them. If you're not going direct through the line, and you're kegging, just tell them how many kegs. That's the easiest way to do it. And then, of course, we already talked about security measures. There's nothing fancy required here. Just a locked door is generally fine. When you're opening something different, like a distillery, they actually have additional rules for like the type of lock that needs to be on the building and a certain minimum standard that it needs to meet. But for beer, it's less regulated. So let's talk briefly about state. And again, each state is going to vary, but I think giving you Pennsylvania just as a brief example will help you to see something similar to what your state, I'm sure, does. So Pennsylvania is governed by the Liquor Control Board, the PLCB. They do have a cost for submitting the application. It's about $1,400, and you renew it annually. That's the minimum amount. You can add permits on top of that, and we'll discuss that. Or actually, since this is a nationwide presentation, I don't have the other slide. The permits that you can include, just as an example, off-premise catering, that lets you go to farmers markets. You can also do Sunday sales. Pennsylvania, being a older state, still requires you to pay a fee to then serve beer on Sundays. And you can also do what's the third one that I'm forgetting about? There's off-premises, Sunday sales. It'll come to me. But anyways, so you can add additional things to your license that permits you to have certain benefits. Things that the state is going to ask you for, it's going to be everything that the federal government does, but also they want more about your personal situation, your employment history, where you've lived for the last 5 years. They're going to want a copy of your driver's license. Here we require a headshot, nothing fancy. You can literally just take it on your cell phone and just upload it. It's something that they have so they can, when there's an agent who shows up, they know who the owner is. You're also going to need to do an individual financial disclosure form, the Form 1842. Again, it's looking for who's funding the brewery, but it's pretty much the same as what the federal government wants, just in a different format. Then you're also going to have to give them bank statements for the last 6 months so they can match up that information to the financial disclosure form. So, there we go. I did have this on the slide. So the other permit that I forgot about, in addition to Sunday sales and off-premises catering, is an amusement permit. So if you want to have live music, dancing, things like that, you have to pay a little bit more money as well. Now, again, here in Pennsylvania, all three of those combined is less than $400 a year. So we're not talking anything crazy. That's certainly worth it, if you're going to be open on Sundays alone. But it's something that you need to add on top of your license, whereas for your federal license, none of that is specified or differentiated in any way. Once you submit the application in Pennsylvania, then Harrisburg, our state capital, has 30 days for the inspector to review it. The initial person has 30 days. They submit it to Harrisburg, and then it can take up to 60 days for Harrisburg to review it. They will then interview the actual owners, members, and managers, those people that we mentioned who you submitted personal questionnaires for before. That can be done during COVID. They were doing it by FaceTime. It can also be in person. It's simple. They just want to talk to you, meet you, make sure you're the person you say you are. but it's proof that the state is a more hands-on process than federal, who really doesn't care and trusts you that you are what you say you are. Also, the PLCB will actually come out and physically inspect your premises and make sure that it is what you said it is, and it's good to go, and the same as the diagrams, whereas again the federal government will not do that. One thing that you can do is you can submit all your plans to the PLCB in advance, get it pre-approved, and then once you're done with construction, have them come out and take a look. A big benefit of that is if something's rejected in your construction plans, then you know to fix it before you've spent all the money on construction, only to find out you have to make a change. So that's something that I would recommend doing. Okay, so once you're up and running, you now have, your business is formed, you have your insurance in place, you have a federal license, you have a state license, you're serving beer. You're open to the public. That does not stop your obligations as far as what you're going to do as a brewery. After you're approved, you got to make sure you pay your taxes. Again, we have a team of accountants that we recommend that do the tax portion of things, but you need to keep account of those things and make sure that you're paying taxes. That's the biggest thing the federal government wants, is you to pay your taxes on the beer. Also, here in Pennsylvania, we have to undergo RAMP certification, Responsible Alcohol Management Program. You have to do that within 180 days, and everyone who's going to serve beer should do it. A lot of states have something similar. Here, you also have to submit monthly reports of the amount of barrels you sell. Your state may have something similar. And then as far as any changes, so just because you got licensed doesn't mean you're good forever. If you make any changes, you have to report it. For example, did a new owner join your business? Is there a change to the brewery name? Did you move locations? Did you expand and move down the street to a bigger warehouse? They need to know that, because your space that you got licensed is the only space that you have for your brewery. So if you move, they want to know that. For example, here in Pennsylvania, like I said, you get 2 storage facilities. So if you're adding locations more than just the one that you have, they need to know that. And then here as well, there's this thing called safekeeping. It's a scary word that really is very simple. You just go online and click a button. But if you are closed for 15 consecutive days and not doing anything with your license, it needs to be put in safekeeping, and then you can take it back out of safekeeping when you reopen. So let's say you're shut down. COVID was a big concern for this. A lot of people, we waived the fees and people could put their license in safekeeping. But let's say your brewery has a fire and you're shut down for 30 days. Your license has to go in safekeeping. Again, any of these with a square bracket that say PA are state specific, but it should be a warning to you to check your state as well. Okay, labeling is a big one. So just because you brew the beer doesn't mean that you can then smack any label on it that you want and sell it, generally speaking, nationwide. From a federal perspective, you need what's called in the industry a COLA, a certificate of label approval. Now, this is only required if you're selling across state lines, but even if you're not, it's still a good idea, and it's perfectly fine to have them so that whenever you do start crossing state lines, you're good to go. Additionally, a lot of states do have similar requirements if you're not going across state lines, and regardless of what the state's rules are, if you have the COLA, that's usually sufficient in and of itself. It's not hard to do. All you need is you need to include your beer name, the name and address of where it was bottled or canned, the ingredients for any added flavor. So you don't need to put in like malt, but if you added, citrus peel or ingredients, those need to be in there. It also needs the alcohol content. For beer, you need to be within 0.3% alcohol, plus or minus, or else you violate federal law. You can be fined by the government. You can also be sued. I know of a brewery who people go around and test the alcohol by volume and then get a plaintiff to sue them and say, oh, our measurements read different than what yours are, and you're either overselling or underselling your beer. So be careful with that. A lot of people will farm it out to a third-party company and just say, you test it for me, and you assume the responsibility that it's done right. But make sure no matter what, you're within 0.3%. You also, of course, need the Surgeon General warning on the label. That's the same, don't drink this if you're pregnant. Don't drink this if you, have certain health issues. That needs to be on there as well. When you make your label, you're going to have to submit it to the TTB, and then they're going to approve it. It can be quick, but it also can take up to 90 days. Again, if there's a federal government shutdown, that can impact things. So the point of this is do it in advance. You don't want to have beer that's ready to be canned and then be like, oh crap, I forgot to do the label, submit it right now, because by the time you get the label approval, you may be then kind of old and stale on your beer. So do it in advance. Also, the government may push back on certain things if they think that your label promotes health in some way or is false advertising in some way. They're going to challenge that. So you may have to fight back on it and see what it is. For example, there was a beer with the word heart in the name, like King of Hearts or something that was not a play on health at all. But the TTB pushed back and said heart implies health, things like that. Trademarking. This is an optional one, and frankly could be a lot earlier in the presentation as well. A lot of clients that I have will trademark the same time as they do their initial business formation. They can trademark the logo, the name, a certain slogan. You can also trademark individual beers. You don't need to do that for every beer, but if you have a flagship staple beer that you're going to sell and it's like your number one, maybe you do want to get it trademarked. That's something that requires you to apply through the U.S. Patent and Trademark Office, and it's a special process that does actually require an attorney. And generally speaking, that is first in time, first in right, meaning if you come up with your name and you love it and you sell here in Pennsylvania, someone in California can rip you off and go sell your brewery name tomorrow. And because you don't sell in California, they're allowed to do that. But if you trademark, then you have nationwide protection. So it really helps you a lot to have that authority of the federal government saying, no, this is your name, your trademark, you're protected. Otherwise, all you have is, as I say here, the common law right to the geographic area that you sell in. So it's a lot better to trademark. It's not expensive. It's something that, can be done and will really protect you on the back end. As long as you have the trademark, we can then send out letters on your behalf, like a cease and desist saying, hey, you're infringing on this, please stop, or else there, may be legal consequences. And those letters usually work pretty well. A recent example of how significant this, trademarking issue can be is Stone Brewing versus Molson. Just earlier this year, there was a $56 million verdict against Molson because of these Keystone cans that you see on the left of my screen, because the word stone, they basically removed key from it, and Stone Brewing said that it was infringing on their trademark. A jury in federal court agreed with them and awarded $56 million. I actually think it was just this past Tuesday that the judge upheld that verdict and said that he's not going to change the amount. So these things really can, if you're big enough, be a significant fight. And the point of this is just that you want to be the one who has the trademark and has the control so that you're not on the bad end of $56 million. Another option you don't have to go the litigious route. There's Avery Brewing and Russian River. I don't know how many of you are familiar with that story, but it's one of my personal favorites. Avery's a bigger brewery out of Colorado. They had a beer that had a certain name to it. They realized that Russian River had the same name, and rather than suing them, wrote them a letter and said, hey, we're really sorry about this, but we have that naming right. Is it okay if you and your lawyers meet with us and our lawyers? Let's see if we can work something out. We were a small brewery once. We don't want to, screw you guys over. So they met. They realized that the breweries and the beers would go well together. They collaborated on the beer, and today they still sell it, collaboration on litigation, and they split the profits. That to me is a very cool thing about the alcohol industry, is that it's not super litigious and you can do those interesting workarounds like that. But again, you want to be the one with the trademark in Avery's position to say, look, I have the power to do A, B, and C, but I'd rather work with you, because if the other side has it and they're coming after you, you're at their mercy. So that's why, even though it's not required, trademarking really is a good option. So the final portion of this presentation is, once you have all that and you're in place and you're up and running, what are the other things to consider? Now, up until this point, we've talked about formation, we've talked about insurance, we've talked about the licensing and what you need to do to keep your licensing running. The rest of this presentation is something that, frankly, with existing breweries, I spend an entire topic on and just do by itself. And I'm going to give you just a brief rundown of it here, because I think it's useful to think of these things. These things are scary, and I get it. And the point of this is not to scare you. It's not to deter you in any way. Again, I would encourage you all, if you're really interested, to open up a brewery, but it's good to be aware of these things and have them in your forethoughts when you're doing things for the business, because it'll help you to prepare if there's an issue on the back end. So with that said, let's just go briefly through some of the areas of litigation that can impact a brewery that you want to avoid. Number one is dram shop. Dram shop is the fancy legal phrase for over-serving someone alcohol, and then something happens, they get injured, they injure someone else. The reason for the phrase dram shop, it actually comes from England. The unit of measurement for alcohol used to be a dram. It was a super small amount of alcohol, I think like an eighth or a quarter of a teaspoon, but that's why it's called dram shop. For anyone who is curious. So if you're over serving someone, generally speaking, the standard is you have to be visibly intoxicated as a precursor as well to this whole thing. It varies by state. Again, check with your state, check with who does these kind of things there. But here in Pennsylvania, it has to be visible intoxication. So just because they blew a crazy high, BAC level does not mean that you're liable. It has to do with were their eyes bloodshot red, was there slurring of the words, things like that. The concern with dram shop is if you are found to have overserved someone alcohol, then even if you're only found 1% responsible for that accident, you can be 100% responsible for the damages. Now, that's an exception to the usual rule here in Pennsylvania. Normally, if you and I are in a car accident and we're found to be, head on, two people at a stop sign, 50-50 at fault, and let's just say that they award the other person $100,000, I only owe $50,000 of it, 50% of the ultimate amount. There's a specific statutory exception for dram shop as a deterrent from over-serving people. So that's why those suits are so significant, is because if you're found at all at fault, you're going to be responsible for all of the damages. Another thing that you'll commonly be sued for is nuisance. That would be, if a neighbor says that you're being loud or have issues at certain times, that's where we talked about earlier, wanting to make friends with your neighbors. You're not doing something that would be subjectively unreasonable to them, but there's also an objective standard of it. Would a reasonably prudent person find that to be unreasonable? I defended one of these cases here in Pennsylvania where there was a neighbor next door who they put 10,000 hours of footage of, all this bad stuff that was happening, people being loud, blah, blah, blah. We went to the police and we filed a right to know request, and we got from the police proof that these were the only people that ever called the police on them, and that the brewery was perfectly fine. They drove by, sirens off, windows down, could hear a pin drop. And then we were actually able to send that to opposing counsel and say, hey, you really sure you want to bring this case? And we were able to work it out in a really good way that required very little on their end as opposed to doing a full lawsuit. And so that kind of thing can be a big benefit if you have the right policies and procedures in place. Again, giving them your cell phone number, doing what you can to be respectful of the community, that kind of stuff. Premises liability is your slip and falls. Here in Pittsburgh, ice on the sidewalk. If you lease a property, unless your lease specifically says that the landlord's responsible for it, if they slip and fall, they're going to sue you as well. So you want to be prepared for that. Contracts. We review, we draft, we negotiate contracts. If there's ever an issue or a breach of a contract, one side says the other violated it, you have to be ready to defend it and say what you did properly. Some other interesting areas that have come up: products liability, exploding bottles. If you brew beer and there's too much sugar in it and the bottle explodes, someone can get injured by it. There was a woman here in Pennsylvania who got her eye got cut and she filed a suit for personal injuries for that reason. So that can be something. Design defect. This is what I think was a funny one and made me think of Chappelle's show that you can see in the left-hand corner for anyone who's familiar with that of the slide. Someone actually sued saying that the beer was defectively designed in that it made him drunk. That's the case of Cook versus Miller Coors. It was in the federal court of Florida, Middle District in 2012. Luckily, the judge threw that out and said, no, it did exactly what it was supposed to do. Beer is designed to get you drunk, and you were irresponsible in whatever you were doing. So it just made me think of the Samuel Jackson, it'll get you drunk. But something that can happen, and if you get sued, again, you're going to need to defend it, or hopefully you have insurance in place. A big new one is ADA website. So your website, every brewery is going to have a website advertising itself. It needs to be compliant with blind screen reader technology. We see literally hundreds of lawsuits have been filed recently in Pennsylvania for various industries, for websites that allegedly are not compliant because they don't work with the blind individual's screen reader. So I've defended breweries for that. I've defended other businesses for that. the best thing you can do is, before you have a lawsuit, reach out to whoever runs your website and make sure that they are compliant with blind screen reader technology. Add an accessibility statement to your website, and also make sure that they are the ones, there's language in your contract with them, defense and indemnification, that if there's a lawsuit and they built your website, they're the ones who are going to defend it and indemnify you. That's really important. And again, that's one of those benefits of having a lawyer help you with that contract up front. Will save you tens of thousands of hours and dollars on the back end. Another big example, false advertising. I'm sure you're all familiar with the Super Bowl corn syrup ads back in 2019. I think it was Anheuser-Busch said that Miller Coors uses corn syrup in its beer. That spawned a slew of litigation out of the federal district in Wisconsin. Avoid that kind of thing, but those can be suits. Also, Blue Moon. Someone sued Blue Moon as a class action, saying that they were a craft beer. They advertised as being a craft beer, and they said they paid a premium for that beer, but yet it's really brewed by Miller Coors, and it's nowhere on Miller Coors' website. So if you're a big enough brewery, that kind of thing can happen. A last area would be auto accidents. So, if you are self-distributing and someone gets in a car accident, which is inevitably going to happen while distributing your beer, you can be sued for that. And so your auto insurance will kick in for that. But you want to make sure you have the right policies in place to help defend that suit. For example, does your driver keep books? Is your driver trained on proper and safe driving practices? Things like that. Those can really help you. So again, talking to a lawyer, myself, or someone in your area who can say, hey, here are the best policies and procedures to put in place, that if you do get sued, these are really good exhibits to put up to the jury to help defend you in the case. Let me jump back, because one that I think would be a good example for any of you, we talked about over serving someone dram shop. Some things that you can do: have a policy, and I mean a written policy, and also post it on your wall. If someone is drunk at your brewery, you will pay for their Uber ride home, because then if they end up going home, you can say, if we would have seen it, or they would have had an issue, or they would have even voiced to us that they weren't comfortable, we would have bought them an Uber ride. And that's the kind of thing that, put it up as Exhibit A to a jury, that looks great for you as a defense, as opposed to if you don't have those policies in place. Also, make sure that your employees are getting trained properly. They're repeatedly training. They're signing, in their employee handbook, I acknowledge that I've received an employee handbook and I'm familiar with this, and my employer has trained me on this, and if I ever feel like I'm getting rusty, I will ask for a refresher course, that kind of thing. Because when they ask you in discovery, give me all the documents that support what you did to prevent this from happening, it looks really not as good when you say we don't have any than if you say, sure, here's everything, we do a ton, and we did everything we could to prevent this. Other than litigation, there's some other areas that we cover and things that can be helpful for you. Zoning hearings. If you're going for some sort of a variance, if you want outdoor seating that otherwise wouldn't be allowed in your area, lawyers can show up and represent you for that kind of thing, help you to make sure that goes through properly. There's a lot of red tape and a lot of local small government nuances when you're dealing with something like that. So it's good to have representation for those kind of things. Tax reassessments. If you buy a spot that was an old abandoned warehouse and then you fix it up into this bright, shiny, beautiful brewery, I promise you the local school district is going to try and reassess your taxes, because they want more tax money because the value of your property just went up. You don't need to just pay whatever they say you should pay. You can challenge that and negotiate it and meet somewhere in the middle. There's arguments that can be made to disagree with the value of the location. Easy examples: just because you bought it for that price doesn't mean that it's what the value should be. You can say, number one, I made a bad deal and I paid a premium because I really wanted this specific location, but it doesn't mean it's what it's worth. Number two, you can say a lot of the things on the inside came with it, and that was part of my decision, and those internal components are not part of the overall property value. So just some simple examples. There's also employment law. You're going to have to deal with hiring and termination decisions, American with Disability compliance, contracts, an employee handbook, things that any even non-alcohol business would have to do. And so doing it with, a lawyer really helps you out and can get you in a better place. The law can be a shield. Again, everything we've talked about up until now, a lot of it has been defensive. It can also be a sword, things that help you. For example, in your employment agreements, you can have non-disclosure and non-compete agreements. One thing I personally love about the beer industry, non-competes are not very popular. Generally, people want you, if you're a brewer, you come up through the system and you want to go open a competing brewery, people are supportive of that. And unlike a lot of businesses, breweries help one another. So you don't necessarily want to restrict someone from competing in opening up their own thing, although you could still choose to do that if you want. But another thing that we do recommend a lot is a restrictive covenant or a non-disclosure. So that says if you're my employee, and during my time that you're my employee and you come up with a beer and we make it here and we sell it as our brewer or as our beer, that's our product. And if you go somewhere else, you can't take that recipe with you and we're allowed to continue using it. It's our property. That's a really good clause to have, and it protects you from them taking your recipes and trade secrets if they leave. Now, again, you can always choose to waive that and give it to an employee if you want, if there's a specific reason, if it's a family recipe. But just like cease and desist and trademark, if you want, you should be the person in the power position to make that decision to be able to give it to them, as opposed to saying, I want that recipe and you have no contractual right to it. Now, if you are going to have those restrictive covenants, they need to be reasonable. And that means that it has to be reasonable in business interest. If you're going to say you can't use my recipe, you can't say you can't use a recipe for pizza, because I'm a brewery. So, pizza is a different business interest. It has nothing to do with it. You also need to limit your geography. So if you, generally speaking, sell beer within a 50-mile radius, you can't restrict them from doing anything or even brewing beer in a 500-mile radius. You're going to keep your area protected, but you can't expand beyond that. And then also duration. Again, you can't make this in perpetuity. It has to be for a set reasonable amount of time. They can challenge any of those in court, and then the court will set a determination as to what is a reasonable amount of time, amount of distance, and business interest. I think those are really the main areas. And again, start to finish, the things that you should be considering as far as when you're opening up a brewery, things to look out for, things to be aware of. Like I said, if you have any questions, no matter where you are, I would highly recommend reach out to me. If I can help you, I will. If I can't, I will find the right person in your area that you can trust to do so. If you have questions about the presentation, if you have comments about the presentation, if you have feedback or other areas that you're interested in addition to whatever questions we're about to ask, email me. I'm always looking for new topics that I can present on, and you telling me what area you care about is very helpful. Again, I have two links at the bottom, QR codes. The one on the left is the link to my bio on our company website. The one on the right is a link to the Brewery Law booklet that my company has put together. It deals with mainly Pennsylvania law, but again, it deals with a lot of what we've discussed here today and has the actual legal authorities that go along with it. So with that, I went just over an hour. I have about up to 30 minutes left, and I'm happy to answer whatever questions you all have.
All right. So if anyone has a question, please use the ask a question prompt here at the bottom. We currently don't have any questions. I have one for you, Aaron. Sure. So when we've been presenting a lot on like financing and thinking about that for opening a brewery, can you give us a range? Obviously, there's a lot of things that depend on it, size, location, state, all of that, but a range for what someone should budget starting a brewery, and then also annually for an attorney or a lawyer.
Sure. So as far as the brewery itself, you're correct that it ranges a lot, and it depends on what size. You can start as small as a half a barrel system, which is going to be very cheap, or you can go up to buying your own physical building and having, a 20 barrel production that's huge. So really it depends on the size and what you want to do. You should think about, you don't want to just go cheap and do the smallest you can, because you might outgrow it very, very fast. So really think about the area that you're in and the size and things like that. Putting aside the cost of the equipment and the cost of the rent or the building, because that'll vary by where you are and things like that. Just as far as your permitting and your licensing and things like that, again, it's actually very small, likely less than $2,000 to $3,000. Again, it depends on the state. Big states, New York, California, maybe more. Small states, maybe less. As far as legal fees, I can tell you that we usually tell people for our area to get a brewery up and running, which gets you through, the business formation, the licensing, any issues like that. We do charge by the hour, and it'll vary based upon, are you a one-person brewery that's relatively mainstreamed, or do you have multiple owners that's going to require some more nuances? Do the federal and state government push back on your application at all, or is it pretty seamless? But generally speaking, I like to tell people and quote people, for me, it'll usually take about 5,000 to 10,000, depending on how hard of a process it is. But that's a good amount to budget in. And then what we do is we take the initial 5,000 as a retainer. It's a fully refundable retainer, meaning that if you ever don't need our services or we're done early, you can get it back. But if not, we'll keep it up, and then we'll just keep using that at the end of each month in order to continue to do whatever work we do for you. And then we continue to put in those increments as needed. If you don't have the 5,000 up front, some people finance it, some people go on a payment plan, whatever it may be. But generally speaking, for just the legal side of it, 5 to 10 is a good range to get you from home brewer with an interest to I now have a commercial license.
Great. Looks like we have quite a few questions that have come in. So Brian says, are there any specific things to look for that might be different when looking to purchase an existing brewery?
Yeah. So unlike a restaurant license, and again, this is going to vary by state, but unlike a restaurant license or something where you actually need to buy an existing license off of someone else, you do not need to do that for a brewery. And technically, at least here in Pennsylvania, the brewery license itself is non-transferable, meaning you can't just go ahead and say, I'm going to sell it to someone else. What you can do instead is you have two options. If someone that you want to take over the brewery for, they can close out their license, and then you can start a new one from scratch with your own name. And then you can buy in an asset purchase agreement their naming, their goodwill, things like that. That's one way to do it. The other way is to do a change of ownership. That's probably the easier route, because then you're not starting from scratch, but then you're just moving it. And so basically you're becoming the new owner of that brewery. They're both options. Both would definitely require federal licensing changes, and then state, it would definitely require something, but it would vary by the state.
Great. Okay. Next one is, are you allowed to use combination of kegs and serving tanks if you are a brewery and not brew pub?
Yeah. So the brewery versus brew pub, for the most part, is just what they want you to label yourself as. Again, either one is fine. And either one also depends on the state. There literally are times where I submit brew pub for my federal application, but then I'm a brewery as far as Pennsylvania. So for example, in Pennsylvania, a brew pub has a different legal meaning, where you actually have a minimum requirement of how much you have to brew. There's different hours. You cannot self-distribute, things like that. So when you're doing your federal license, submit which one applies to you more. And then as long as you, no matter which way you're doing it, whether going from fermenter to the tap or to the keg, as long as you have a way to measure it all and pay your taxes, generally speaking, you should be fine.
All right. Next, what is required for label approval for keg collars, as they are usually generic with brand specifics written in when attached to the filled keg?
To my knowledge, you do not have to do anything special as far as a keg. It can be blank. A lot of breweries will put names and put, colors on it for fun. And it, again, brings out your individuality and stands apart when you're giving it to, whether it be an actual, person buying a keg or another entity. But the reason for the certificate of label approval is that when you're selling to a consumer, the individual, they need to know how much ABV is in it and how much of these other things. So just to give you an example, when you're doing a growler, you do not need to have that on there. It's only for the cans or the bottles. So growlers are another interesting workaround where you can just fill it and it doesn't have to have any of those things. A lot of breweries did growlers when I was mentioning the government lockdown. It was 3 or 4 years ago, the government went through a bigger lockdown. And so a lot of people weren't getting their certificates of label approval. which means you can't can it and you can't sell it with those cans because they haven't been approved. So what people were doing as a workaround was selling it in growlers. So you can put whatever name you want on the keg, you can put a color, but you don't need to get any sort of federal label of approval for that.
All right. What kind of paperwork or agreement would be required to procure a distribution network, local or statewide?
Great question. So if you're talking about signing with a distributor, again, it's going to vary by state, but really it's just a contract. You're a business, they're a business. You have what we call, as far as the law, an arm's length agreement, meaning you're coming with neutral bargaining power. Not to say, of course, that you are in neutral bargaining power, but the fact that you're a business as opposed to an elderly man or woman who gets swindled by a large company and there's unfair trade. If it's two businesses, you can enter into whatever contract you want. So it depends on whatever that distributor has. And again, a lot of these distributor agreements from way back in the day, like late 1800s, early 1900s, are one sentence, and they just say, I'm your distributor. Courts have upheld those in perpetuity, which is nuts to me, quite frankly. I would highly recommend that you not just enter into whatever they give you. Again, have a lawyer, have me, have someone else look at it and negotiate it for you, because you want to limit it so that it shouldn't be in perpetuity. There is protective language in there. Although a lot of times people will uphold for a distributor that, you can't just cancel with them. There has to be a material breach, is the legal term. And again, that's a big fight. What does the word material mean? But you can put specific clauses in there that might be helpful. Like, you agree to refrigerate our product to a certain temperature, and you agree to ensure that X number of cans get there within your control. Tangible, very specific things that you can show they're breaching if you ever have an issue. So, you agree that you will distribute at this degree temperature for this many cans, as opposed to you will do what is reasonable, which, who's going to say what that is?
All right. And last one. As far as putting some daylight between your business and your personal name, is that true for trademark too? Is a trademark filed in your own name a liability?
So actually, funny enough, trademark is the one area that I don't personally handle, because it comes with a special bar that you have to take in order to be with the U.S. Patent and Trademark Office. As a brand new practicing attorney, the day that I come out of law school, I can literally try a death row case. There's no restriction against that. I cannot file with the U.S. Patent and Trademark Office. To my knowledge, I see no benefit in you submitting it in your own name, and it should be in the business's name. I also can't imagine how that in and of itself would really contribute to liability, but it could be used against you to show that there's not a distinction of corporate formality. So I would, no matter what, I would recommend that it be in the company's name. And then as long as you're the owner of the company, it by, transitive property is yours. To circle back about what I said about not being a patent trademark attorney, again, that's something that I have a close personal friend who works at the same law firm as my wife, and we partner with them to do that and get it done for a very reasonable price. Again, someone who was asking about pricing, trademarking, if it's simple and it's just the name or the logo, you're looking at only like $2,000-ish. So it's not bad.
All right. I think that is all we have as far as questions. Thanks again, Aaron. We really appreciate it. And just a couple of reminders, I will send out a copy of the presentation. So we'll have Aaron's contact information on there. Please feel free to reach out if you have any questions or you're looking for a specific attorney. And then last but not least, we have our next presentation, August 25th. So thanks again for joining us, Aaron. We appreciate it, learned a lot, and thanks everyone for attending. Have a great day.